Welcome to Objection to the Forum. This is Justin Humphreys, and this week we've got a great guest, Jeremy Wilson with the law firm Ward & Smith. When I started this project, Jeremy's one of the first guys I thought that I wanted to have on because he's very insightful, and I would say kind of in my age group, who I consider to be one of the best civil attorneys and one of the best communicators, and so it's a pleasure to have you on today. Jeremy's been with Ward & Smith for I don't know how long.
Yeah, since 2011. I worked for a little bit in between undergrad and going back to law school, but since 2011 I got back down here.
And one of the things I think makes Jeremy so impressive is that I believe your first job out of college might have been teaching.
It was, yep.
And I think that's one of the things Jeremy kind of approaches his arguments almost like a teacher. It's very professorial and it's very easy to understand. A lot of times I know you'll be sitting there waiting for your motion to get heard and you watch everything that's going on. And I kind of like to pretend like I'm the judge and decide who I think is going to win. And half the time I can't understand what's going on. But every time I see you argue a motion when I'm there at the same time, I always get it. I always presume you're going to win. You usually do. And it seems to make sense to me. So I'm excited to have you on today.
Well, thanks so much for saying that. I'm not sure any of that is true, but I really appreciate the nice introduction, and it's an honor to be on the show. Definitely enjoyed the teaching experience. I taught high school math for a couple years up in Henderson, North Carolina, and I've said it to other people before, and it really is true. It is amazing the kind of training teaching is for practicing law, because you're taking these, it was high school math. Nobody finds that very exciting, right? So you're taking these sort of complex subjects that maybe people don't find really interesting unless they get in the weeds, and trying to explain it in a distilled way that makes sense. So I try to approach law that way. A lot of times it doesn't always work. Sometimes it does, but I do think that informs the way that I approach some of my legal career.
Well, and that's kind of one of the things I've noticed when you've got a judge or a jury. They don't know anything about your case, and a lot of times we've been working on it for a year to a year and a half, sometimes longer, and we see all these get lost in the details sometimes. And so when you take somebody cold from the outside that has no clue what your case is about, sometimes it's better to kind of approach it like that rather than jumping straight into the facts and being able to kind of present it in a format that's easier for them to digest and understand.
I think that's so true, Justin. And we're talking about jury trials earlier today, and that's a perfect example. I really believe in the institution of the jury trial, and I really believe juries get it right the vast majority of the time. But you've got people coming in, they're away from their regular day job and away from their family. They can't look at their cell phones. They don't know anything about the case. Not thrilled about being there initially either, like I was saying. And you really do have to distill the case down and explain to them why it's important to be there and what the case is about.
So I got a question for you that's kind of I've heard disputed quite a bit in jury selection and just jury trial behavior. Do you thank the jury? And what I mean is thank them for being there.
Yeah, I do. I mean, I've heard people say that that's not effective to say thank you. It's almost condescending. It's not the right word, but something like that, like you're pandering to them a little bit.
Patronizing. Maybe.
Yeah, there you go. That's the right term. I do. I just can't help it. I mean, I'm from the South. I say thank you a lot, and I know it's a big sacrifice. I mean, I don't overdo it. I don't wax poetically for minutes about jury service and its importance. I say it's important because it is, but I do slip and say thank you. I know some attorneys don't.
Well, and I've gone back and forth on it, and I kind of am more in your camp on that issue because, really, if you want to find a way to get out of jury service, you probably can. There's you're not supposed to, but there's excuses, there's hardships. A lot of times I'll see attorneys in jury selection just ask the juror pool, straight up, if you don't feel like being here, let me know.
Right.
And I don't know, is that something that you do?
Yeah, I try to get a sense of it. Certainly the judge, when you're doing jury selection, asks if anyone has a conflict that would prevent them from being there. It's part of our civic duty, so, the most of the judges I've been in front of, it's got to be a really strong excuse for them to be let go for cause. But I certainly do try to get a sense of, whether or not they can be there. And it is an inconvenience. I get that in everyone's life. You are away from your family and your job, and that's a big deal in this day and age, as busy as we are. But if someone's really on the edge of just sort of being angry because they're there, and that's something you think about. You want the jury to be open, and you want them to use their common sense and experience in a fair way. And if it seems like somebody just isn't in a position to do that week, that is something that I try to get to.
Yeah, and I think with a lot of what's going on about currently with the need for police reform, or for whatever you want to say, however you want to look at it.
Sure.
I think one of the best ways people can reform the legal system, aside from changing laws, is through jury service. Because that's one of those things. It's one of the things that people have been upset with has been kind of the results in some of these civil and criminal trials where police officers have have been accused of using excessive force, and really, it's kind of a community judgment decision as far as what the community is going to tolerate. And unfortunately, you see a lot of the people that complain the most about the legal system, where you hear people a lot of times. A lot of my friends, kind of making lawyer jokes or talking about how the system's messed up, but those are the same people that tend to be the first to get out of jury duty when they get summoned for it.
Yeah, it really is an important institution. And look, easy for me to say. I've actually not been on a jury before. It's fairly rare for lawyers, it seems like, to get picked for jury service. It's happened. I know some lawyers that it has happened, but I think sometimes other lawyers worry about that a little bit. But I get that I've got my biases about being a lawyer and doing jury trials. But, it really is amazing how you take 12 people from the community and they make these hard decisions that both sides couldn't agree on. I don't do any criminal law, but it's similar in that situation. You have the DA and the defense attorney and the client that couldn't come to an agreement about guilt or innocence or a plea. But in the civil world where I practice, you've got these fundamental disagreements about what happened or what the damages are, and we say we're going to get 12 people from the community and let them make the decision. It's a very democratic and very powerful thing.
What do you think about the decision? Do you think it's better to strike a attorney from the jury pool, or do you like to have attorneys in your jury pool?
I've actually never had one that actually got into the box before, into the jury box where they were a true prospective juror. I've had paralegals. I've left a paralegal on before. They were let go by the other side. But I think an attorney, I'd be open to it. You do worry. The role of a jury is to decide the facts and then apply those facts to the law. And sometimes with attorneys, there's nothing wrong with knowing the law in depth, but I think the classic concern is they're going to kind of play lawyer armchair quarterback and think too much about the law and the behind-the-scenes stuff and not do sort of the direct deciding factual issues role that juries do. And you're worried that lawyers would have a hard time sticking to that role. So I would certainly think about it. I'm not going to say I would never do it, but that's kind of the concern that people have.
And that makes sense to me. The one time I left an attorney in the jury box, he ended up being the foreperson. And so it's you can tell that that's the person they wanted to kind of take charge of the deliberation.
Sure.
And so I guess it's one of those things that if you're on the fence about an attorney, you might want to strike them, because they're probably going to be, the jurors are going to be looking to them maybe for advice on some of the issues.
Did you talk to after that trial? Did you talk to that attorney afterwards, who ended up being the foreperson?
I did. And he said they all just kind of looked to him right when it started. They didn't deliberate all that long. What was funny about it, it was Ashley Edwards, who I clerked at a firm where he was a partner in 2006. And the way it went down was, I when he got called to the box, I said, hey, just in the interest of disclosure, this guy used to be my boss, and I forgot who the judge was, but he said, so are you saying he's biased? I said, no, I'm not saying he's biased, but I just wanted to bring that to everybody's attention. And I think the opposing side thought I was concerned or didn't want him. And so they, I didn't, maybe they thought I left him on because I was concerned about, or we didn't get along, or I got fired or something like that. I don't know.
Right.
But
that would never happen, Justin. Come on.
No, well, I didn't. And he ended up starting his own practice a year or two later, so we didn't work together very long. But yeah, he's a great guy, and he did a good job on that jury. But I was surprised they left him on.
Yeah, sure. One of the attorneys I've spoken to who did serve on a jury, and it was a contract dispute. It was a couple-day long trial. It wasn't super complex, but this was somebody who's done a lot of jury trials, really well-established litigator. But he said it was fascinating seeing it from that side, and you always hear the complaint that lawyers sort of waste time in the courtroom, and he was like, that is so true when you're sitting on the jury. I mean, we're all addicted to our smartphones, and you can't look at your iPhone, and you got other things to do. You're thinking about what's going on back at the office, and then you have attorneys asking the same question over and over again, or taking a long time to find an exhibit and things like that. That's one thing you point out that was really interesting, how you really appreciate that sort of those delays and that timing.
Yeah, and one of the things that helped me is I started volunteering with the high school mock trials.
Yeah.
And watching those, and you can see kind of what how legal training has a way of confusing you, and kind of making it to where you speak less clearly, or you maybe don't present things like you would. Because the high schoolers that hadn't been through that, they just kind of identify the issue, they get to the point. They might not be the most skilled at cross-examination, but they're as good as some of the lawyers you see. And it's interesting for me because sometimes I would be the judge, other times I'd be a juror, and it was it helped me kind of with what you're saying, is trying to figure out, what was persuasive and what wasn't, and
right.
Just the time wasting that happens in the courtroom, how much more efficient it could be.
Sure, that's great you've done that. I've done that a couple of times too. I'll tell you, some of these high school kids are great. Like, they would smoke me in the courtroom. I'm just like, oh my gosh, like, they're really skilled. The other funny thing about that, sounds like you've done it before too. I've only served as a judge in those mock trials once before, but gives you an appreciation for being a judge. I mean, obviously we have appreciation for judges. They do really important work, but that is not an easy job. And I sort of had some attorneys that were quick to object, and it was just like objection after objection. I was like, man, it's hard to make these calls on the fly like this.
Yeah, and then sometimes, I would and these were short trials too, and so I kind of catch myself dozing off, and then I hear objection. I'm like, wait a minute, well, what are you objecting to now? What do you say about the? And I was kind of making them rewind it so I could I didn't get caught napping on it. But
ask them to explain just to buy yourself some time.
And that was my 2.5 hour high school mock trial instead of some of these, these long ones that these judges do. So it definitely gave me an appreciation for what they do and kind of the focus you have to do that job.
Absolutely. And I'll tell you what's one thing that's amazing about jury trials is there's fewer and fewer of them these days. You talk to attorneys that were practicing, 20, 30 years ago, and I won't say it was the default to go to trial, but just so many more cases were getting tried. And I'm going to mess up the numbers, Justin. I think a couple years ago, the number of civil jury trials that went to verdict was like a little bit over 100, like 110 or something like that in North Carolina. So you're 100 counties, you're a little bit over one per county. You have fewer and fewer of them these days. And I know we've both tried cases and still try cases, but it's getting more and more rare for that to happen, and certainly a whole nother a whole nother topic we could open up. With COVID, it's going to be a long time too till we're back to normal with trials.
Yeah, for sure. I don't know when that's going to get started back up. One of the things that I think is interesting is you would think, with trials, the expense and the time and the risk, you would think that only the really big cases go to trial, but from my experience, it seems to be the much smaller ones that end up going. Sometimes you'll have a car insurance company and a plaintiff's lawyer, maybe haggling over $1,000, and then it ends up being a 1 to 2 day trial or things of that nature. Maybe it's because of a lower risk involved. I don't know. But are you seeing some of the bigger things go, or do you think it's more the smaller cases that are being tried more often?
I think your point about the smaller ones is a good one, and I think part of that maybe is there's less to risk by going to trial. There's always uncertainty with trials, and especially when there's a dispute about liability, whose fault it was. I mean, it could be something or zero if that goes the wrong way. And you just never know for sure what a jury's going to do. You can get a good sense, but you never know for sure. So the smaller ones, with maybe there being quote unquote less to lose, maybe that would make sense. Sometimes the bigger ones go just because there's a fundamental disagreement about an issue. You see that in medical malpractice cases where there's a fundamental disagreement about whether or not there was malpractice. And so, you're not just negotiating over amounts of money. You've got a true disagreement about whether what happened was wrong and should have been handled differently. And so some of those larger cases, particularly when there's a liability issue, or if they're just they still tend to go sometimes. And even, there's exceptions to all this, even on some of the larger cases due to damages. Pain is such a hard thing. We could talk about pain and suffering later maybe. That's such a hard thing to value. And a lot of times there's fundamental disagreements on that, just how you fairly compensate someone. So you see some large ones going too, but it certainly is more rare.
Well, so are you doing much medical malpractice right now?
Yeah, we do some. We absolutely do.
What I've heard is the people that are in that area have kind of told me that they have to feel like a case is a slam dunk if they're going to take it as a medical malpractice because of the expense involved and the having to procure, I guess they call it, I was getting ready to say the 9J certification, but that's kind of the shorthand for hiring a physician or a doctor in that doctor's field of practice to kind of certify that there's a potential case.
Right.
And do you have a pretty strenuous vetting process for a medical malpractice? How does the medical mal vetting process compare to just maybe a typical car accident or something of that nature?
Sure. That's a really good question. We always try to vet them very carefully. They are for a couple of different reasons. One, you want to make sure you're right. I mean, it's medical professionals, doctors, nurses. I mean, it's a hard job. I come from a family of nurses. I've got many nurses in my family, and you're making hard decisions with people that aren't doing well, and if you're going to take one of those cases, you want to know you're right about it. And there are mistakes that happen, and they have tragic consequences, so there are valid cases out there. But we take our time and analyze them to really make sure we're right and believe we're right. But you're correct. They're so expensive and difficult these days because largely tort reform, and that's those changes that have been made in civil lawsuits involving injuries. Medical malpractice cases particularly had a bunch of tort reform, and so they tend to be very expert driven, and that can be expensive to even file them. Like you were alluding to, you've got to have experts review everything, and that it leads to costs and time and those sorts of things. And you've got a cap on damages too. That's the only type of personal injury case where pain and suffering damages are capped. So in terms of, and there's a current fight, and I've got my views on it about whether or not that's constitutional, but at this point there is a cap that's on the books, and that changes the analysis too about how much sense does it make for a family to press ahead on one of those cases.
What are you seeing in terms of the damages that juries are awarding? Because from my perspective, the pendulum seems to swing a little bit depending on public opinion and kind of the mood or the standards of the community at the time. Mm-hmm. Would you say right now is a plaintiff-friendly environment, or do you think that the jurors maybe in Southeast North Carolina are still fairly conservative?
Yeah, I'd be curious on your thoughts because you've got so much great experience on this stuff too. I mean, I think there's certainly folks that talk about different counties being more conservative than others, and I agree with you. If you look at the averages of the numbers, the pendulum seems to swing a little bit. I mean, you heard about these large verdicts in the 90s and early 2000s, and then you had tort reform after that, and that seemed to restrict verdicts a little bit. I think we're probably somewhere in the middle, and maybe it's me being naive, but I do think that juries tend to get it right. So I think in the right case, and I use right loosely because these are such sad circumstances in the personal injury cases I deal with, that they do the right thing and they factor things in correctly, not skewing one way or the other necessarily.
I know it was a little bit before our time, but how much impact do you think the McDonald's Coffee case has had on jury verdicts? Because it seems like it gets addressed in half the trials in voir dire that I see. Somebody feels like it's the elephant in the room or something
Sure.
they need to discuss. I mean, do you think that's had an impact on the way people view personal injury verdicts?
Yeah, sure. And I've got good friends that are on TV and they do a great job, but sometimes you'll get like the YouTube commercial of the personal injury attorney that's a little bit over the top, and that sort of creates a view of what personal injury attorneys do. And then that McDonald's case, which is sort of fascinating. I think there's a Netflix documentary on it. I've never watched it. I've listened to some podcasts about it. But if you really understand the facts of the case, it wasn't a ridiculous outcome by any means. And actually, I think the verdict got cut down on appeal in addition to that. But yeah, it's one of those things that's just sort of out there in the public psyche, and people hear about it and they feel like maybe somebody who's a plaintiff is out there trying to get a bunch of money, maybe not deserving it. That's a bias that maybe, and we all have biases about things that maybe some people come in with because of hearing something like that.
And that's a value decision, that I guess that the jurors are being asked to make is who deserves what. And what I kind of think is that if the jurors knew the whole story, it would be different. Because if you're looking at it from this person is asking for to be compensated for the pain they experienced or for the effect it's had on their lives or the expense moving forward. They might look at it as, well, they're asking me to give them something. Mm-hmm. But if they knew kind of the background, this is more times than not insurance money.
Right.
That's the whole purpose of it being there.
Yeah.
And that when you get injured or if something happens to you, you're going to be, the shoe's going to be on the other foot. Mm-hmm. And so I've kind of referred to it as kind of like the crab mentality, where sometimes people are like, well, I'm not going to give that person anything, that my back hurts too, or my neck hurts. So they're trying to pull them back down with them. But in a lot of respects, that's kind of how you can change the community standards is by saying that, we're not going to tolerate this behavior. We're at least going to treat people fairly and try to compensate them when they get in that position.
Sure, absolutely. And I know you view this the same way too. I just think credibility is so important when you're in that courtroom. I mean, you need to be honest with the jury and help them understand why you're there. And you're not there because your client is trying to get something they don't deserve. You're there because they were forced to be there because something bad has happened, and money doesn't fix problems, but that's the way our civil legal system approaches it. You receive compensation for medical expenses or lost wages, and then pain and suffering on top of that, and other types of damages too, to balance out those harms. And you can't unwind the clock. People wish that you could, but because you can't do it, that's the way our system works. And we could have a system that was different. We could have a huge governmental social system that pays damages, but through the private insurance industry and through the civil legal system, that's the way we've chosen to approach it. And I think jurors understanding that. You can't talk about insurance usually, but understanding why they're there and what that process looks like, I think helps.
How do you articulate to a jury that you would like them to compensate your client for the pain they experienced?
That's a really good question, and that's something that I think jurors struggle with, because how do you put a number on that, right? If somebody's got chronic pain the rest of their life, how do you assign a pain and suffering damages amount to that? And the jury instructions ask jurors to do that using their experience and their common sense. So it's what seems right based on that. I really focus a lot when I'm doing a closing argument on the jury instructions, because they're going to hear that from the judge, and talk about following the law and what the law is asking them to do. So we talk about that requirement, and then what tort law tries to do, and it's a legal fiction because money doesn't replace what happened, but it tries to make somebody whole. So it's really based on what they're going through and what seems right, and there's no right answer to that. We have the benefit, Justin, of looking at other cases and seeing what jurors have done with other cases. Juries have done. Jurors don't. So I do think they're looking for us in a closing argument to give them some suggestion of what we think would be appropriate. But it really depends on the facts of the case and what happened and what somebody's going through.
So I've seen, there's a firm I've seen that's out there that has this thing they use in closings called the pendulum of damages.
Gotcha.
Or not the pendulum, the continuum.
Continuum
of
or
damages.
It's something.
So,
I know what you're talking about. Yeah.
So they'll be like, all right, this is a strained neck, that's worth $20,000. Broken leg is worth $50,000, and then they'll theirs is usually on the much further side, so they'll say, well, a permanent disfigurement, that's $250,000. So then it's like, there's obviously no legal source for that, but they're just saying, look, this is what it's worth. And I have questions whether that's permissible in a closing, but people,
right.
You don't want to. Nobody wants to object during a closing and get shut down, because then it almost reinforces the continuum. But
sure, gotcha.
Do you ask them for a specific number, or I guess the question would be ask versus tell? Like this is $100,000 worth of pain, give it to them.
Yeah.
Or this broken leg's worth $100,000, or is it we would like 100 in light of the facts of this case?
Yeah, I'll share my thoughts, and again, I think it's all about credibility. I'm not going to put a number out there. It starts with the client first of all, or the family. They're the boss, and so we talk about it first, obviously. But I do think a jury, because it's so hard to value those things, is looking for some guidance, and I will suggest a number or a range. I don't usually give a specific number and say you must award this. I mean, it's up to the jury. It really is. It's their decision to make. But I will look at the numbers with them. If it's a case where there's permanent injury, and in North Carolina law, as you know, you can look at someone's life expectancy when that's the case. And we'll talk about assigning dollar amounts per year for future pain and suffering, what they've been through up to that date. And I'll suggest numbers and look at what those numbers would look like when you add those in with the other damages, and make suggestions about what would make sense to me based on my observations. So I'll suggest numbers and try to help them with that process, but I really believe it's their decision, so I won't give them a hard and fast number that I feel like they've got to award or something like that.
Gotcha. And that, and I've seen it done both ways.
Yeah, to each their own. People do it differently. Yeah.
Yeah, and so with respect to just kind of you mentioned the families being the boss. Mm-hmm. And so have you had a situation where you've got, maybe a small to moderate case, and then they'll say, Jeremy, I need you to go in there and tell them to give me $1 million, or ask them to give me $1 million. And do you ever have a situation where you've said, no, I'm not doing that because, it's my credibility is at stake out here, and I'm just not going to say this is a $1 million case, or I'm not going to demand that even though that's what you're asking me to do?
Yeah, that's a really good question, Justin. I've never had that happen at trial, and I think part of that's the nature of getting a trial. By the time you get there, you mentioned earlier that it takes a while to get through that process, right? I mean, at least a year, usually longer, frankly. At that point, you've had offers and you've had mediation, and you've sort of come to an agreement or an understanding of what you're looking for and what you're demanding. So you're kind of in the ballpark anyway. there certainly are hard discussions sometimes about earlier on in the case about what the right amount to demand is, and I get that. That's hard, especially in tragic cases. There's no amount of money that makes things right in those sorts of cases. So how you try to figure that out, and a lot of times it's based on insurance and what comparable cases have looked like at verdict and those sorts of things. But there absolutely can be hard discussions about that, and I get it. I imagine you probably had some of those same discussions too.
Yeah, sometimes I try to weed that out to my best of the ability in the earlier on in the case or in the initial consultation stage. Sometimes, that'll come out earlier, and a lot of times it's always, well, I had a friend or I had a family member that had something similar and they got X amount of a recovery, and I just, in my opinion, I don't think that's realistic expectation, and try to do it. But things do have a way of changing throughout the course. I mean, some people can take offense to what's happened throughout the discovery process because it can be fairly invasive. Now, I'm sure you've probably heard this a bunch of times, but when somebody says it's not the money, it's the principle of the matter. Mm-hmm. So that typically means it's about the money. That's kind of what I always say. Like when I hear it's the principle of the matter, okay, that means it's money is what you're talking about.
Gotcha.
But that's kind of like my antenna perks up when I hear it's the somebody early on says it's the principle of the matter. Then I kind of think, well, I don't know if I can make you happy with this because there's all we can do is just get money is really the only thing in the civil system.
Right, within the constraints we have, and a lot of cases are tied to insurance, and we were talking about this earlier today. There's limits on insurance a lot of times, and in North Carolina for different policy reasons, it's not always easy to collect. I mean, if you are negligent and don't use reasonable care and hurt somebody, ultimately you're on the hook, but it usually comes down to insurance, and unless you've got a bunch of assets, it can be difficult to collect against the person at fault. So a lot of times you are tied to what insurance is available.
One thing I strongly believe is that it's crazy to have a minimum limits policy. Mm-hmm. I mean, one, if you have assets, you're exposed to an excess verdict of people coming after your own belongings. But the bigger reason is the vast majority of people on the roads in this area are covering $30,000 worth of coverage. Mm-hmm. And if you have a minimum limits policy, you're not going to be able to get any uninsured or underinsured coverage. And when you see it, I got a new policy the other day, and the difference between $250,000 per person and $500 per accident and $100-300 was something like $30 over the course of 6 months, or something crazy. That can be a night and day difference if you get involved in a serious accident. So I guess I typically don't give the purpose of what we're doing isn't really to give legal advice to anybody. And I think we've got
to clarify
this
is not legal advice.
Yeah, but what I will say is go get adequate insurance. I mean, that's one thing aside from participating in juries and doing what's fair for people. That's another thing you can do to kind of look out for yourself and other people is to spend the extra $50 a year and get adequate liability coverage and UIM and UM.
Yeah, you're so right about that, particularly the uninsured motorist coverage or underinsured motorist coverage, because that's really protecting you in the sense, I mean, it's not protecting your assets, but it's protecting you and your family members and other people in your car. If someone else causes an incident and you get hurt and they don't have enough insurance, most drivers have small limits on their policy. $30,000 is the minimum in North Carolina, like you said. And if you go to the hospital and miss some work, I mean, you can blow through that $30,000 pretty quickly. And having that underinsured motorist coverage, it's on your policy, but it lets your insurance step in and pay damages or compensation to make up for a lack of insurance on the other side. And it really can protect you and your family member. And unfortunately, once an accident happens, it's too late to change that. You've got to change that on the front end. And hopefully people never need that, but it's something where it's a huge benefit to have, and it's usually not a huge amount of money in terms of what it costs to move those limits up.
How do you go about kind of marketing yourself? Because we mentioned kind of some of the over-the-top things you see on YouTube or the phone book, which I guess the phone book's kind of you don't really even see that anymore. I get upset when somebody leaves a phone book. I'm like, what am I going to do with this?
What is this thing?
It's going to take up half the trash can. This is terrible. But or I guess YouTube is the thing now, or still TV commercials. Like if you ever sit around sick, from daytime television, you're going to see a lot on Judge Judy and those shows. But how do you go about marketing yourself and kind of getting out of that fray?
Yeah, that's a really good question. And like we were talking about before and speaking to a jury, to each their own. People do it differently. I'm at a larger firm. I'm at Ward & Smith, and we're 90 attorneys across the state in different offices, and we don't just do personal injury. So, we tend to do more general type of marketing, and it's never something we've done to be on billboards or be on TV and have a personal injury specific message. Some folks do that, and that's great. We just don't. So a lot of what I personally do is just try to let people know the type of work I do, and I've got great relationships with excellent attorneys like you to let people know the type of work I do, or just sort of generally knowing people in the community. But you do some stuff online and some things like that. But no, we've just never done some of the TV ads and billboards and things. But some people do, and that's effective. And I think tastefully done, then it provides a benefit where the community knows that that's available and what legal rights are there and those sorts of things.
Do you find in jury selection, because I want to talk a little bit about what you're looking for in a jury, or do you find that it's more the details of each case, or if you've got a personal injury case, you've got a certain profile for a juror that you want to look for?
Yeah, that's such a good question. It's again, maybe I feel like some other attorneys, if they see this, are just going to think I'm naive. I mean, I don't really get into the weeds too much of we want this particular type of person, some of the demographic stuff, age or whatever else. I truly am trying to get a feel for who's on the jury and just want people that are going to be open about being there and going to try to approach the case fairly. Really, that's what I'm looking for. It's hard, and I guess if you had some huge month-long trial and brought in jury consultants, that'd be a little different. But it's in your classic case, you're not spending days and days with the juries. You're just trying to get a sense of their background, a little bit about them, and make sure they're comfortable following the law and don't have any sort of true conflicts where they know somebody or something along those lines. So, I'm really looking for people that are going to be open-minded. I'll talk through what the case is about. You can't get into it too much during jury selection, but, you can talk through a little bit about the case and the type of case it is and just make sure they're comfortable awarding damage amounts and holding an at-fault party responsible. But honestly, that's what I'm looking for at the end of the day. How about you, though?
Well, I guess I typically have kind of I go into it saying this is kind of my ideal juror for this legal issue or for this case. But that being said, I think you can't be too stereotypical about it, because there's people with the main key is whether they'll be fair, and then different folks, just because of their job or their demeanor or familial status, they might have different outlooks. So I don't believe you have to be rigid with it, but I do kind of have some kind of things I'm looking for typically when I am picking a jury. But
we still get it wrong sometimes too, which is funny. We were talking about that earlier. I think I mentioned that story. I had a trial that went to verdict, and there's this one juror that was on there, and she just wasn't looking at me during the case, and during closing argument wasn't making eye contact. I was like, she really doesn't like me, and it just isn't understanding what this case is about. And I'll be darned, you can talk to the jury afterwards, and you can talk to them right after the verdict, or you can call them and speak to them. And she got it, and she was very much on the side of our folks and what they went through. And it's funny to me, as much as we study these things. I know you do and read so much, and you know so much about these things, but even doing that, you really don't know for sure until it all sort of shakes out.
Have you ever worked with a jury consultant before?
So I've done focus groups before. I've not had a jury consultant on site at a trial. I've spoken to a jury consultant before about a case, but I've not had somebody there in the courtroom.
What's the difference in or what happens in a focus group? Because I've worked with jury consultants before, but never done a focus group. How does that work?
People do them differently. The way that I've done them is you get some people to volunteer to come hear about your case, and some people call it a clopening, like it's a closing mixed with an opening, but you basically explain to them what the case is about in more of an argumentative way. I mean, you can't argue during an opening statement. Usually that's for closing, so you kind of put all that together and talk about what they would hear in the case and those sorts of things. I mean, I think people that get more into it even have some witnesses come in or have some tape testimony and those sorts of things, and just get feedback from the focus group. So it's sort of like focus groups in politics, right? See how regular people respond to a message that maybe sounds great in your head, but maybe doesn't work.
And I think that's probably where they're most useful. Just kind of trying out themes of your case or seeing what what issues really upset people that you might not realize, or maybe ways to frame things. I've heard of people, and I haven't done this, but kind of almost do a full-blown mock trial, and not like the 2.5-hour high school ones. Like they'll put on a full, week-long mock trial to get ready for something. And I think that's a little bit of overkill, because a lot of what happens is kind of reacting on the fly, and you don't know what evidence is coming in for sure and what evidence isn't. And it seems like a lot of it might be kind of, I don't know what the right word for it is, but it overkill certainly, and it can actually put you in a detriment if you have a certain expectation of that a situation is going to play itself out in a certain manner, but you really don't have any control over that.
Yeah, and you're right. I mean, things change so quickly during a trial. That's what's fun about what we do, and I don't want to say fun like it's a game. I mean, these are important cases in people's lives, but we're both litigators, and that's one of the reasons we wanted to be litigators, to have to think on your feet and argue and those sorts of things. But you're right. I mean, I think that's the role, at least in my mind, for focus groups. I mean, you're trying to explain a case to a jury, and if you're doing a bad job explaining it and they don't get it, that can give you some early feedback, as opposed to getting that feedback at trial when it's too late to readdress some of those things.
Yeah. So as far as tactics, I guess, when you mentioned in jury selection asking them about values of the case, are you saying like look, we're trying to get whatever the number is, maybe I'll just throw out $100,000 if that's the number. So would you say to them, look, we're asking for $100,000 in this case? Are you going to have difficulty awarding that if the facts support that?
I won't mention a number. I will talk. The way I sort of start out is you explain a little bit what the case is about. You introduce your client is, who the witnesses are, and you're trying to weed out if anybody in the jury box knows anybody and might have some biases that they don't believe they could get through because of that. And then I will talk about how the law is typically going to work in these types of cases. And this is a personal injury case. You're going to be asked to award damages. Those damages could include these categories. One of those is pain and suffering. And just to make sure that there's no one on the jury that's not comfortable doing that. And it can honestly go both ways. It's not fair to either side if there's somebody on the jury who's just one of those people that believes, look, stuff happens, and no matter what happened to you, you don't deserve compensation. I just don't agree if this is how the law approaches these issues. Well, it's probably not the best jury forum. On the other side, I get this from the defense perspective. If there's somebody on the jury that just says, hey, I don't care if it was somebody's fault or not, give that person all the money they want, that's probably not a fair approach for the defense either. So long answer to an easy question. I'm sorry about that, but I will generally talk about the damages categories, but not specific numbers.
So yeah, and that makes sense. So you're trying to feel somebody out to see if they would have a problem with pain and suffering, just as an overall concept.
That's right.
Do you think pain and suffering is probably the most difficult, the most difficult concept to explain and to get a jury to award damages for that?
Yeah, I absolutely do. And wrongful death cases, when someone's passed away, and the lack of having that person there, similar idea. The non-economic damages that you can't write down on a chalkboard, right? The medical bills, you can add those up and figure out what those are. Lost wages, maybe there's a little bit of a fight about that, but that's math. It's about how you're doing the math. But the pain and suffering is so amorphous. I mean, you can't really put a dollar amount on there. So, but you have to try to. That's what the jury's asked to do. So it's hard.
Do you have any strategies of how to kind of make that real for the jury, or how to request that in a persuasive manner?
It's got to feel right to me, and I know you do this too. I'll talk to other lawyers about what seems to make sense and what feels comfortable, and talk to the family, and you look at other verdicts and those sorts of things. It really does come down to, even though it's a legal fiction, trying to make somebody whole, and what replaces what has been lost and feels like an appropriate number. And I think the jury instruction says based on common sense and experience, and it's yes, told people what seems right, and that's the number. So I try to think through that and use examples and do some math and look at the jury instruction, but there's no strict formula. It's hard to do. Do you have anything that you like to do when you're working through some of those issues?
Well, so from my perspective, and it's kind of like you mentioned the items you can put on a chalkboard. When I'm a plaintiff in a business matter, I don't seem to see the same type of pushback about we've lost $1 million because of this incident, or if it's a condemnation, if not for the government taking this area of my property, I could have developed it to this use, and this cost me millions of dollars. And people don't seem to take issue with that. They're like, oh, that's terrible. They got in the way of your plans. You were going to make all this money. And to me, it's like that's way more speculative than, the person that got hit in a car wreck, or that got, that fell or had a work injury or whatever it may be. But that seems to be offensive to some people. So what I've tried to do is link the pain and suffering to something tangible that you can put on a board, or something by, say, like kind of compare it to a job almost. Like, they had to go to these 20 doctor therapy appointments. They had to drive across town. They had to experience this condition of pain that they, that wasn't their choice. And to kind of, I know you can't do the golden rule, which the golden rule is what would it, what would it be worth to you to have this happen
if you were going through this, what do you think would be the
so
right amount?
You'll get shut down if you do that. But I guess in a way I'm trying to say that without saying it, is they put this person in this situation. They gave them this job that had X amount of trips involved, X amount of doctor's appointments, needles, x-rays, whatever you want to do. And then on top of it, part of the job was to go through pain for this amount of time. And this is what, and then I'll say, this is what that job's worth.
Right. I think that's a great analogy. That makes a lot of sense. I guess I've done something similar. You certainly can't violate that golden rule, but you can talk about the plaintiff and Joe, or whoever your client is. Joe was sitting there before this event happened, this car accident or whatever it was, and you told him, I'm going to give you $100,000, but in order to get that, you're going to have to be in this terrible car wreck, go through surgery, have pain the rest of your life. Would Joe take it? Probably not. And I think that's something that can help a jury, balance, think about what making somebody whole looks like.
So that example, would you say that example you just gave, would you call that a golden rule argument?
You got to be careful about how you phrase it. And so, before I do that, I always sort of think about the law and look at that and think about what's permissible. But, you're asking the jury to put themselves in the plaintiff's shoes, and if they've testified about it on the stand and sort of talked about how horrible it's been, and if a dollar amounts come up in their testimony, which sometimes happens because of responses to requests for statement of monetary relief sought and all those sorts of things, sometimes that can be appropriate. But you're right, you got to be careful about it, because there are strict rules about those things.
And sometimes you see like the concept of what's in it for the juror, like kind of saying like why are these two people or companies monetary dispute, how does that affect them? And that's the way I understand it, that's part of the concept with some of the reptilian the reptilian approach to being a plaintiff's lawyer, and I think that's probably there are probably better terms they could have come up with to describe it, because when you think it's like reptile approach, it's kind of like, well, that sounds like a sleazy plaintiff's lawyer.
It doesn't sound very nice, does it?
That sounds like a...
It should be like the koala approach. Koalas are cute, so it's a nice animal.
Which apparently they'll tear you up.
Oh, really? I retract my statement. Never mind.
And I've heard that kangaroos are like killer deer from somebody in Australia.
You know a lot about Australia. We should do an Australia podcast.
I'm interested. I'm very interested to go to Australia. What the cool thing about the podcast, that they've got it set up to where we've got our analytics, and so it tells you where the people are listening. And so there's one person that listened in Germany and maybe two people that listened in Japan. And I don't know
how about that? That's
stumbled
cool.
across this, but
what if you hit it really big in another country? Wasn't it David Hasselhoff that was like really big in Germany? Yeah.
The Germans love me. Yeah. Two people listened in Germany, but I'd like for people to listen to Australia so I could go see the killer koalas and kangaroos, because that'd be something else.
That's funny, Justin.
But but yes, they should have a better name for it, because it's like, oh yeah, the snakes. Yeah, that sounds exactly like something an attorney would come up with, trying to cheat people out of money or whatever it is. But the way I understand it is they're just saying, trying to make the jury see it in a way to where they understand where the issue that they're hearing and deciding how it affects their day-to-day lives.
Yeah, I think that's right. And, a lot of that's grounded in the role of the jury. A jury is the conscience of the community. They're making a decision about responsibility, typically, in these types of cases. And there's been some more recent North Carolina law that's come out, and I think it just restated what the law has been. But part of these types of cases, in negligence or injury cases, is deterrence. Part of holding people accountable when people or companies are negligent and somebody gets hurt is doing it financially through our civil legal system. And that's not just punitive damages, punishing damages, that's compensatory damages that try to make somebody whole. And I think that's part of it. And there's some rules about what you can say and what you can't about that, but helping the jury understand that their role is important, and what they're doing can send a message about cases like that in the rest of the community. There certainly is something to that, and it is an important role.
Has there been a judicial response to the reptilian mindset type there? Or I might be mischaracterizing the approach. I read a book, 6 years, so I'm not, I don't purport to have it all down, but
Sure.
Has there been a response from the judges or through the cases where they say, kind of like with golden rule arguments, you can't ask them to put themselves in the shoes of the plaintiff, have there been certain phrases you can't use or certain concepts you can't put before a jury in light of this kind of newer approach?
Yeah, not in North Carolina, not any monumental cases that I've seen. I've seen some cases where jury instructions that were maybe based on that analysis were questioned on appeal, but nothing explicitly going towards some of that language or that approach more generally. The best example is probably the case I was alluding to that stated that it's okay to talk about deterrence in those types of cases, that part of what you're doing is trying to deter similar conduct, and that's in line with some of the approaches you're talking about. But no, it could be the case in other states, but I haven't seen anything in North Carolina.
Gotcha. Well,
unless you have, I could have missed it.
No. I mean, no, I've not. The main thing is kind of the golden rules, what I've tried to dance around.
Right.
But I haven't heard of any specific cases that change it. It's interesting using deterrence is I've never really thought to do that in the jury argument, especially not in instruction. So I guess people just drafting custom instructions and asking for them to be.
It's just in the closing argument. So they'll and you can talk about the law in a closing argument. So you can reference the fact that the law says that part of what we're doing here is not just compensating the injured party, but through that trying to deter similar conduct. And if that's appropriate for your case, maybe it isn't always, but that's something that the current appellate law says you can do.
Do you have any advice for putting your best foot forward with your client, to making your client somebody that a jury can maybe empathize with and be more likely to give a favorable verdict?
Yeah, and I really do think, and I'm not just saying to say it, but being honest is so important. If you're in there and you're exaggerating what happened or about what happened, or seeming like you're trying to get more than what's proper under the law, you're going to lose credibility, and that's what you don't want to do. I mean, credibility is so important, and I know you do the same thing. I try to be so careful about cases that we bring in and when we represent somebody that, it's a case where it's a very meaningful case that somebody really does need some help, and they deserve what we would be asking a jury for. But I think that's the most important thing. And you don't want to get on the stand as a plaintiff and be testifying and overstate something or exaggerate. You got to be honest. I mean, it's all about credibility in those situations, I think.
Well, and I think that's an important thing to explain to people. And then, maybe sometimes it's like you can't help yourself. Or, I've seen it where people, we've talked about it, we've practiced it, and then they get kind of caught up in the moment. And maybe they're not trying to embellish so much or exaggerate or say something that's not true, but they're wanting to be persuasive, and they're offended by what they've heard, and they feel like they've got to set the matter straight when they get up on the stand, and sometimes things can kind of go awry or kind of run off the tracks from there. But,
they try to be the lawyer a little bit, and that happens, right? It's stressful. You're in that room. I mean, it's not like it is on TV. You don't have a huge gallery back there typically, but you do have 12 strangers in a jury box, a judge, a bailiff, court reporter, clerk. It's stressful, and if you have another attorney that's kind of going after you, it's human nature to want to fight back a little bit. But you're right. I mean, you want to rein that in a little bit and let the lawyers do that piece for you.
I did want to ask you this. So, what are your thoughts about objecting during someone's opening statement, voir dire, or closing argument?
Yeah, look, I've certainly not been doing this forever, so maybe I'll do it at some point. I don't think I've ever done it before. Honestly, maybe maybe once during voir dire, but I can't place it. I mean, I try not to. I certainly would do it if it was something egregious. Like if it was something that crossed the line, I would object. But I try to be respectful and to give some latitude there. They're trying to make their case, and I want them to be respectful of me when I'm doing my part. And like you said before, I think sometimes that backfires. If you're the attorney that's hopping up every 2 seconds and objecting to everything, I think you sort of seem silly and that you're wasting the court's time and those things.
Well, that's kind of my perspective about it, is that I don't, it's kind of a decision of, is it objectionable and does it matter? And like, is it something that, except the things that matter, you're going to try to exclude it ahead of time. Mm-hmm. Now, I guess somebody might make an outrageous argument, or they might do something, they might kind of overstep during voir dire, and so it's kind of a matter of, well, do I look like I want to hide this, or how important is it to shut this down?
Right.
And it's kind of a difficult decision to make, but I know some people feel like it's important to do that to kind of set a tone that you're not going to allow somebody to step all over you or to take advantage of the rules. Others feel like, it's an argument, it's not the facts, it's let people do their thing, because it's gonna look bad or in front of the jury that you're trying to keep information from them.
Yeah, do you have something to hide or something like that? I mean, I certainly will object whenever necessary during a case in chief and about evidence coming in or whatever else. But yeah, I try to stay away from that during opening, or more so opening and closing. Voir dire, I think, is a little bit looser, at least in my mind, for whatever reason. But yeah, I think I do that less than some others for the reasons you just said.
Do you have any thoughts on the use of technology?
I probably should be better at it. I mean, we're a similar age group, so I mean, you're doing podcasts and YouTube shows and everything else. Like, you're good with technology.
I don't know how to use any of it.
I got you. I typically use PowerPoints, and you play videos of testimony and those sorts of things. In terms of like the more flashy stuff where you're putting exhibits on the screen and marking it with pens where the jury sees it electronically, I've never quite gotten into that stuff. I mean, I'm not scared to use some technology. I won't just use the poster boards. I'll use a PowerPoint presentation and those things, but I don't really do as much as some other people do. We all learn that way, so it's probably a good thing to do more of that, but I just typically don't.
I'd like to be better at it, and I think it's like, I'm not opposed to it. I think a lot of times I shy away from it because I don't have the comfort with it, and I don't want to do something that's going to be clunky or, or just, you always have the fear that you might make the best PowerPoint there's ever been, but then you get there and the projector doesn't work, or you can't hook it up to the computer screen, and then you're going to be left like, flat-footed. So I kind of have my apprehensions about it, especially, at least the new Hanover County equipment is some of the most archaic. I want to say the last trial I did, we rolled over one of those carts, like maybe from like high school with the cart with the VCR.
Oh yeah, sure. When it was like movie day.
Yeah, this had a DVR on, or not, it had a DVD player, but it was like tube TV. It was just really, I couldn't figure out how to use it, and it's kind of, you wonder. It's just, I try to avoid it, and I should. Right. If I felt more comfortable with what I was going to be using, I'd probably do it more often.
Yeah, and you're right. When it goes wrong, it goes wrong. I mean, this all worked out fine, but I had one up in Pitt County, a trial, and was trying to show a web page, and we were going to the live web page. I was going to show it through a witness, and they were going to click on it and bring it up, and I'm so stressy about it. I check it like 10 times that morning. Everything's working fine. As soon as I want to do it, it's like the wireless isn't working in the courtroom. I mean, and eventually it came on a couple minutes later after like sweat's pouring down my face. But yeah, when it goes wrong, it goes wrong. You want to have backup plans for those things.
Yeah. Have you ever had experience with creating a day in the life video?
Yeah, sure have.
And so that was something interesting to me. So I didn't even realize these existed. And I had a client that was a wrongful death client. And they contacted me pretty early on after the incident, and I guess we were talking about marketing. Some of the a lot of the attorneys send out letters and try to contact. Some of them are more aggressive, but they were contacting her, saying, "Look, you need to get on this right now. We need to be filming the funeral. We need to be, because they were trying for the day in the life video." And I was like, "Well, what are you talking about?" And she explained to me, like, we got this attorney told me I needed to start doing I needed to film the funeral, and I needed to film like me with the kids on this wrongful death thing for the day in the life video, I guess, to memorialize the grief. And I was like, well, I'm not into that, but if you feel more comfortable, I'll let you out of your contract if you want to go do that. And she was like, no, I don't have any interest at all. I just want to make sure we're not missing the boat here by not doing that.
Mm-hmm. Yeah, that's interesting. I've heard of stuff like that. I've never done it in that context. So, if there's a case that's bad enough in that you've got a client or family that's going through some pretty serious issues. There was one where there was a child that was injured and really bad injuries, and their daily life was just very tough. It was hard to get around. It was hard for the family to take care of them. In those situations, it's sometimes hard for words to do it justice. And so that was one where we used a video to help the other side understand, and if it had gone to trial, the jury understand what the family was going through, because we didn't feel like we could adequately explain like how tough it was. So, and we did it very, I think, respectfully and tastefully, but it was just, look, hey, this is an example of what we're talking about. This is how so-and-so gets to school or whatever else. That other example, that's not something we've done. Like anything else, I think it's about how you do it and for what purpose it is. And if, in my mind, if it's helping explain somebody's case, because it's all about getting whoever, the other side of the jury, to understand it, that's the role I think it's got.
And I think that makes sense to me when you're using it as like, it's one thing to say, because of this incident or because of whatever, I can no longer do this task, or I can no longer, but it's one thing to visualize it.
Sure.
Like, look, this is the physical limitation. This is why I can't do it. And you can see the attempt, and you can kind of see, or you kind of watch day to day what it's like trying to accomplish something that maybe most folks take for granted is being able to do. I think it can have a lot of help visualizing that.
Yeah, I think that's right. Yeah, it's really all about, like we're talking about before, just trying to help a jury understand who's coming in off the street, doesn't know anything about the case, and depending upon the case has a day, a couple of days, a week, not that long with that case, but it's somebody's life, and in a lot of cases they're going to be with that forever, the repercussions of what happened.
Have you run into the use of surveillance at trial very often?
Yeah, so me personally, not too much. I mean, I'm seeing maybe a little bit of less of that. Certainly other folks at my firm, so my law partners have, and other people I know have. Yeah, I think that can backfire. Now, I've had some online surveillance in cases where people are like searching Facebook and family's Facebook and friends' Facebook and just doing a deep dive on that. But in terms of following around somebody with a camera, there's not been one where I was sort of lead on, for lack of a better word. I've dealt with that, but I do think that can backfire. I mean, that's a little creepy to be following people around.
I agree. I mean, it upsets people, and then it's expensive. Most of the time, you're paying by the hour, and if you're sitting around watching somebody, paying somebody to watch somebody's door all day long, it's not going to be the best use of money. And I've kind of seen that where defense attorneys have maybe wanted to use it, and almost a matter of, well, we paid the money for it, we're going to use it. But It's something like, oh, look, this guy said he can't do the chores, but look, there he's taking out his trash. Or someone's like, well, of course he is. It's that's what people do. I mean, is that what? It's one thing if you get the video, it can be outstanding. If you get the video of the guy surfing and or something like that, then it's worth the money. But if you're just seeing somebody just living and really not doing anything,
that's right. Yeah,
and I think the last one I had, it was something like where they did over 40 hours of surveillance, and like the best thing they had was the guy lifting what appeared to be something heavy and putting it into the trash. And they didn't know. And it's like, well, look, it must be heavy. It's like, well, what's in there? How do you know it's heavy?
Right.
Has he struggled with it? Maybe you or I wouldn't have struggled with it, but maybe it's because of the injuries why he struggled with it. Maybe it wasn't heavy. I don't know, but it's crazy that you really want to play this video of you stalking this guy, to the jury. But
I see it the same way you do. And if it's egregious, look, we all need to know. If my client's telling me he can't surf and he's out there surfing every day, well, I probably need to know that. I mean, there's maybe this is not the case for any of us to have. But yeah, I mean that long-term surveillance, we're sort of picking and choosing things, and people try to live, right? And I've got respect for people that are in tough situations and they hurt and they're going through a lot, but they're still going to try to take their trash out or do whatever else. And that doesn't mean it didn't hurt to do it, or that didn't, they weren't out of it for the rest of the evening because they tried to do some chores or whatever else. So yeah, I just think, I'm not a defense attorney, and there are a lot of really good ones, but I think you got to be careful about taking things out of context, because I think that can backfire if you're not doing that appropriately.
I agree completely. Well, Jeremy, I appreciate you coming down there. I really enjoyed talking to you. Learned a lot, and think it was certainly an interesting discussion. And I'm sure I'll see you in court soon whenever that gets started back up again.
Well, absolutely. I learned a lot. It's always fun to talk to you. You've got so much great experience and do such good work here. So it was my honor. Thank you very much for inviting me.